Good morning, everyone, and thank you for joining us for the Medical Board of California Interim Board meeting. Public comments will be heard for individuals wishing to do so. In order to be able to be ready for public comment, we ask please ensure your comments can be heard clearly by being connected to the audio of this meeting through the proper method. If you're having difficulty hearing the audio of this meeting, it could be because the device you're connecting with has bandwidth limitations. If you do have difficulty hearing the audio of this meeting using your device, please click the ellipsis button at the bottom of the WebEx application or the audio and video menu item at the top of the WebEx application, and then select Switch Audio. You will see an option to call in and will be provided with a telephone number, access code, and attendee ID that can be used to connect to the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone to the name you joined the meeting with. By using this method, if you're having audio problems with your device, this will still allow you to participate and hear the audio of the board meeting. Please see the instructions on how to connect link on the last page of the meeting agenda for step-by-step WebEx instructions, including screenshots. Thank you, President Lawson. You can now start the meeting.
Thank you, and good morning, everyone. Welcome to our March Interim Medical Board of California meeting. I would like to ask all of you to make sure to mute, turn any devices to silent. Since this meeting is being conducted via WebEx, I will ask all board members and presenters to please announce themselves by name before speaking for clarity of the official record. All board members are able to unmute themselves to speak during the meeting, but please do place yourself back on mute when not speaking to reduce background noise for all participants. Following this online meeting etiquette will ensure the best audio quality for everyone. During each call for comments from board members and speakers, we will ensure that all comments that can be accommodated will be heard before proceeding with the agenda. This is an official business meeting of the Medical Board of California, and as such, disruptions of the board's business will not be tolerated. Government Code 11126.5 allows the board to remove people who willfully interrupt a meeting and to clear the room or virtual space if order cannot be restored by muting or removing the disruptive people. We do have a designated time on today's agenda for public comment, and we'll ask for public comment on each agenda item. The board's IT staff will assist me with receiving those comments via WebEx during this meeting. The board welcomes public comments on any item on the agenda during open session, and it is the board's intent to ask for public comments prior to the board taking action on any agenda item. During each agenda item, the host moderating the WebEx event will activate the hand raising and the Q&A features of WebEx, and will ask anyone wishing to make a public comment to indicate so by raising their hand or entering yes in the Q&A window. The host will then call on individuals who indicated they wish to make public comments by name. When called upon, the host will unmute the microphone of the individual and they will have 3 minutes to make their public comment. The host will audibly announce when the 15 seconds remain to conclude the public comment, and after the 3 minutes have lapsed, the individual will be placed back on mute. Only one public comment per agenda item will be allowed per attendee. Please see page 2 of the agenda for WebEx instructions on how to connect from the link on the agenda and additional instructions. During agenda item 3 today, public comments on items not on the agenda, the board has limited the total public comment period to 40 minutes. Therefore, after 40 minutes, no further comments will be accepted. During public comment on any other agenda item, 20 minutes will be allowed for each comment period. And after 20 minutes, no further comments will be accepted. Each person will be limited to 3 minutes per agenda item. The board's IT staff will assist me with receiving public comments via WebEx during this meeting, and I would like to remind speakers to please stay on topic and keep your comments to the allotted time or less. Today's meeting will be run in accordance with the Open Meeting Act as required by law, and we plan to end today by 5 p.m. It is 9:05 a.m. now, and I would like to formally call this meeting to order and ask that board members please unmute their computers so that Ms. Lopez can call the roll. Ms. Lopez?
Dr. Balat.
Here.
Mr. Brooks.
Present.
Dr. Hawkins.
Here.
Dr. Helzer.
Here.
Ms. Lubiano.
Here.
Dr. Mahmood.
Yes.
Dr. Sai.
Here.
Dr. Thorpe.
Here.
Madam President Lawson.
Here. All right, thank you. A quorum is present. A quorum is present, actually. Board members, please mute your computers again. I would like to remind the members again, we will be taking a roll call vote on each item. We are now going to move to agenda item 2, which is a closed session. We will be back in open session at some point following this closed session. I don't have a specific time that will be back for those attendees that wish to rejoin us for open session. But board members, I think the time is now. And Sean, I don't know if you have any additional instructions for us, but we're going to move into our closed session meeting via separate WebEx.
Sorry, President Lawson. Yes, y'all should have an invitation for a closed session. I'll send you a reminder right now as well, and we will see you over there. For all public attendees, we will keep this meeting open, and you know, when the board members are coming out of the closed session, I'll go ahead and change the message on the screen to let everyone know that they're returning before we proceed with the agenda. So you're welcome to stay here during that time. Thanks very
John.
much.
We'll see you in the other closed session. Thanks.
Very good.
All right, thanks, Sean. I think we'll get going because we have a quorum and we have a lot more to do today. So, Sean, do you have any announcements before we get going?
No.
Great.
There you go.
Well, welcome back, everyone, to the open session. For those members of the public who've joined us, thank you for your patience as the board met in closed session earlier this morning. The next item on the agenda is public comments on items that are not on the agenda. Before I ask for public comments, I would ask individuals that are making comments during this agenda item to please not discuss pending complaints, pending license applications, or pending disciplinary actions that may come before the board in the future for a decision. Such discussions would be considered ex parte communications, as they could provide information to members that is outside of the record in violation of the Administrative Procedure Act. Therefore, such discussions could create a conflict and could lead to a board decision being challenged in Superior Court. The board can receive comments regarding the board's processes in general, but it cannot receive comments on specific case circumstances where a decision is still pending. In addition, the board requests the public to address the board as a whole and not individual members. Please be aware that public comment during this agenda item should provide information to the board members and unfortunately is not a discussion between the board members and the public. The only action that board members can take is to listen to comments and decide whether they'd like a future agenda item on the topic. No other action can be taken on the item at this meeting. Though at times this may seem like board members are not being responsive, complying with these guidelines is essential to ensure the rules of the Open Meeting Act are followed and to avoid compromising the speaker's goals or the board's mission. If you want to comment on one of our agenda items today, please do wait until we get to that agenda item. Comments at this time are only for items that are not on the agenda. Please limit your comments to 3 minutes or less, and I will now ask the host to call for public comments. Sean?
Thank you, President Lawson. The hand-raising features in the Q&A window have been activated for anyone wishing to make a public comment. You can go ahead and use either of those. No need to type your full question in the Q&A box. You can just type in there you'd like to make a comment, and we will go ahead and call upon you. And I don't see any call-in users, but just in case, if you're on a phone-only line, you can press *3 to toggle raising your hand on the phone there. We'll call on you by your area code usually. First up here, we have Marion Hollingsworth. Marion, let me go ahead and send you that request. Okay, Marion, you should be receiving that prompt there momentarily.
All right, I clicked it. Can you hear me?
We can, yeah. Please go ahead.
Thank you. Good morning. My name is Marion Hollingsworth, Patient Safety Advocate. At the last quarterly meeting, I recommended that I would like an agenda item to address conflicts of interest and ethics. This was in regards to Dr. Richard Thorpe, a board member, being subpoenaed to testify on behalf of a doctor at a hearing. At the time, I thought this doctor, Michael Gruber, had subpoenaed Dr. Thorpe himself because, according to board documents, the two had been colleagues at Adventist Hospital. I have since learned that former Executive Director William Persifka had the Attorney General's office subpoena Dr. Thorpe. It was not Gruber, who, by the way, got off with a reprimand for harming 5 patients, one of whom died. So is the board now fighting on the side of doctors against the harmed patients? Can there be an agenda item to explain how the subpoena is not a conflict of interest and how many other times this has happened? It is the board's statement to protect the public. Is that irrelevant now? After the subpoena, how can we trust you when you say your purpose is to protect patients? I would also like to request an agenda item on AB 1636. This is the new law to prevent doctors from getting their licenses reinstated if they were revoked or surrendered for sexual misconduct or sexual exploitation. It's the result of an LA Times article about doctors who got their licenses back after sexually assaulting patients. AB 1636 was touted as a huge step forward in patient safety. However, we were all duped. The board says it is still reinstating doctors despite 1636. Less than 2 weeks after 1636 went into effect, this board reinstated the license of a doctor who had been revoked precisely for the violations specified in 1636, misconduct and exploitation. When I questioned this decision, Jenna Jones said it doesn't affect doctors who had already lost their licenses. Wasn't that the entire point of the bill? 1636 doesn't give any effective dates. It says it shall not reinstate. So the way the board is interpreting it, this bill really won't take effect for years after the next crop of doctors is revoked for sexual misconduct. Meanwhile, the previous offenders will get another chance to assault someone, and one of these doctors has just moved into my area. How can you put us through the charade of supporting such a bill if you can put your own spin on it in order to get more doctors reinstated? Again, an agenda item on AB 1636 is needed, as well as one on conflicts of interest. Thank you for your time.
Thank you for your public comment. Next up here we have Kristen Ogden. Kristen, you should be receiving that prompt on your end. Morning, Kristen. Looks like your line's open.
Hello, can you hear me?
We can. Please go ahead.
Thank you. Good morning. My name is Kristen Ogden, and I'm here speaking today on behalf of Families for Intractable Pain Relief. I just want to comment that we continue to look forward to a report on the status of your pending update to the California prescribing guidelines for controlled substances, and we hope that we will be hearing more about that in the near future. Also, I want to advise you that legal action by patients to intervene on behalf of our doctor continues in the case brought against him by DEA. The DEA administrative judge denied our motion to intervene. We have taken the first steps to appeal that denial in the Court of Appeals of the District of Columbia Circuit Court. Meanwhile, many patients suffer needlessly, and some are rapidly declining. Just please be advised that many of these patients are in California. Many are in the LA area. They suffer needlessly, and we will never give up. Just please understand, sometimes we have to confront barriers that seem entirely inappropriate and unfair, but we will never give up. Thank you for the opportunity to comment today.
Thank you for your public comment. Just double check here, President Lawson. Okay, this time I don't see any additional hands or, oh, hold on, sorry, last second request here. Let's see, Arcadio Viveros. Give me just a second to find you here in the list. Okay, should be receiving that prompt there on your end to unmute. Morning. We can hear you. Please go ahead.
Yes, my name is Arcadio Viveros, and I'm the vice chair of the board of San Benito Health Foundation. I don't have the agenda that you have. So I was wondering if at this time I could speak regarding a request for the support of the board for legislation AB 1395 and 1396 regarding the...
Sir, that will be up on our agenda. That is agenda item 7. We're currently on agenda item 3. So I'd ask you to just please hold that comment and we'll
wait.
come back to it.
Very good. Thank you.
Thank you.
Great, thank you, President Lawson. At this time, I'm not seeing any additional requests.
Sounds good. We'll bring it back to the board. Thank you all for your public comments. We will move on to agenda item 4, which is board member communications with interested parties. As a reminder, this is an opportunity for board members to disclose if they've communicated with interested parties on items that are going to be coming up for discussion during this meeting. Do any board members have anything to report?
Madam President, I'd like to go back to the public comment first, because I do have an agenda item that I'd like calendared for our next meeting.
Okay, let's talk about that, Mr. Brooks. I think we have a future agenda item.
Oh, we do. Okay.
I thought we did. Let me just double check. Yes.
We do.
Agenda item
All right.
8.
I apologize. So I'll wait until that time.
Great.
Dr. Hawkins,
Dr. Hawkins.
I've
Go
had
ahead.
discussions with multiple medical schools and local medical societies about PTL and physician surgeon licenses and issues. And that'll come up again when we talk about item number
6.
6. Thank you very much.
Thank you. Other board member communications with interested parties.
President Lawson, similar to Dr. Hawkins, mostly in academic medical centers and the PTL.
Thank you. Additional board member communications with interested parties.
President Lawson, this is Dick Thorpe. I also had individual communication with residents regarding their PTL and interim licensure.
Thank you. Other members have reports to make? All right, like Dr. Thorpe, Hawkins, and Bolat, I've had communications on the PTL issue. I've appeared before the legislature in our sunset process and have had a number of conversations leading up to that hearing last week with legislators on a variety of issues, some of which will be on our agenda today. But let's move on if there aren't any further board member reports. All right, Sean, I'll ask you to call for public comments on board member communications with interested parties.
Yes, I left the Q&A window and the hand raising feature activated. Anyone wishing to make a public comment can use either of those. And if you're on a call and only line, you can press *3 to toggle your hand. First request here we have is for Christina Hildebrand. Christina, you should be receiving that prompt. Morning, Christina. Looks like your line's open.
Can you hear me?
We can. Yeah, please go ahead.
Hi, Christina Hildebrand, a Voice for Choice Advocacy. I have to say that I'm not very enamored with your declarations of who you've spoken with. You need to tell us exactly who you spoke with, not just, oh, legislatures, or I talked to people on this issue. Who is it you talked to? Who are the people you talked to? That's when you disclose who you have talked to. You need to share who you've talked to. Furthermore, I know that many of you, or some of you at least, have spoken with CMA members on the Sunset Review, because the CMA, in their public comments, stated they were in negotiations with you on the amount that the Sunset Review or the licensing would be increased to. None of you mentioned the CMA as being one of the people that you've talked to as an interested party. So I would like you to redo this and actually state the people that you have talked to with regards to any agenda item, and actually state the names of those people and what you talk to them about, and make this a true disclosure, not just some general statement that means absolutely nothing. Thank you.
Thank you for your public comment. Next up here we have Monty Goddard. Monty, you should be receiving that request on your end. Looks like you're connected by phone too, Monty, but you'll have to use the unmute button on your computer or cell device, whichever else you're connected to as well. Okay, Monty, I'll try one more time here and let's see if. Okay, Monty, I'm not seeing you unmute your line, so at this time, President Lawson, I don't see any additional requests.
Thanks. And can the person identified as Monty perhaps email their comment to webmaster@nbc.ca.gov if you'd like to make a comment, since it doesn't appear that is working. All right, we will move along to agenda item 5, discussion and possible action on responses to legislative questions asked of the board related to sunset review. Mr. Bone.
Thank you, Madam President. Good morning, board members. On Thursday, March 16th, the board leadership and executive team appeared before the legislature for our sunset review hearing. As part of that process, boards going through sunset review are expected to provide written responses to the various issues identified in the background paper, which was written by legislative staff for that hearing. For this sunset review, the board's background paper identified 18 issues for legislative consideration, and that is linked in the agenda items write-up, as well as prior examples. Each issue includes a recommendation from legislative staff, which serves as a prompt for the board's response. Some of the issue recommendations include requests for the board to provide specific information. Others provide the board the opportunity to reaffirm the legislative proposals included in our sunset report. As the hearing was just a week ago, staff have not yet had the opportunity to draft these responses. Instead, we hope to use this time to receive suggestions or recommendations from the members. Madam President, if there is a desire for a motion on this item, I would recommend that it be to delegate to the President and Vice President to consider the comments from the members today and work with staff to draft and submit the responses to the legislature. That concludes my prepared remarks. I'm happy to answer any questions.
Thank you, Mr. Bone. Is the idea that to the extent board members have comments or questions on any of these 18 issues, they should provide them now? And how would the board like us to proceed? Do you want us to go issue by issue, or is there a I guess it's
I think there's multiple. Yeah, I think there's multiple right ways to go about it. So I mean, I'm happy to prompt at each issue, and if there's a comment, great, or then we can move on. I mean, if that's your desire, Madam President, that works for me.
Do any board members have specific comments they'd like to raise, and then maybe we'll go through these various prompts. I think Aaron's proposed motion is a good one for us to consider as well.
Madam President, this is Dick Thorpe.
Dr. Thorpe?
Yeah, I have one. My issue is primarily with the evidentiary standard. I am concerned about the change of clear and convincing to preponderance of evidence, and I think primarily because there is no other regulatory board in California that uses preponderance of evidence as their standard. Clear and convincing evidence is clearly the standard in California, whether it's, California leads the nation in many ways. We have a lot of things that we do in California that nobody else does. Just because we're not in step with the rest of the country in some other way doesn't mean that we should sacrifice this standard to be in step with the rest of the country. Clearly, this is a standard we've set in California for every regulatory board, and I believe we should not sacrifice clear and convincing evidence in our situation just because of the concern for that we're not in step with the rest of the country. Thank you.
Thanks, Dr. Thorpe. And I would just note, so that proposal is part of our new issues under enforcement enhancements. That was part of our sunset report that's approved by the board. So your dissent is again acknowledged to that issue. But I believe that the board currently, and again, unless we want to change our position here, has a position to support that as part of our sunset suite of proposals.
Thank you. I understand.
Yeah.
Thank you.
Thank you.
And there was a lot of good discussion, as you would recall, Madam President, a lot of good engagement with Senator Roth, on that matter during the hearing.
Additional comments or questions generally, and then Aaron, I think we should probably just tick through these items relatively quickly so we make sure to catch any.
Happy to. All right. So for those who happen to have the background paper in front of them, it's linked in the agenda write-up. I'm on page 22 of that, and I'll just I will not read all this, but I will just, give some prompts. So issue number 1 has to do with the board's composition. And, the recommendation there is for the board to provide information about how this change would make NVC more effective and successful.
And that's with respect to our proposal that the board have a public member majority.
Yes, and I would say by and large, these are reflective of the board's proposals. So we already have information that, that I could pull from, in the drafting of this. So that's issue number 1. Issue number 2, and I'll just go through quickly. Please interrupt me at any time, members. Issue number 2 has to do with the research psychoanalyst registration.
And real quick, when you say page 22,
yeah.
is it PDF 22 or the actual page 22?
It's the printed, it says page 22 at the bottom of the printed document.
Thank
So
you.
the top of that page says current sunset review issues.
Thank you.
Great. So moving on to so issue number 2 is on page 24 and 25. That has to do with the research psychoanalyst program and our proposal to move that to the Board of Psychology. And members, I would just add as well that many of these responses are largely technical in nature, like what information could you provide? What's the status of things? How would this work? So I don't expect the members to provide those responses during this interaction. Staff will be doing that. But again, if there's any points of emphasis or matters that the board feels particularly passionate about emphasizing, then I'm happy to take that. Issue number 3 has to do with licensed midwives. It's on page 24 and 25, and the establishment of a new board for them. Again, this is a board proposal. Seeing none, the next is issue number 4, page 30, the complainant liaison unit. And there, the legislature on page 33 is asking for the board to explain how this program could be established, the necessary steps, and the role that revenue would play in bringing this effort to fruition. And again, I think we've largely already outlined this in our sunset report. Unless there's any comments from the members, I'm happy to move on to.
Aaron, I think we just roll through these pretty quick, and if someone wants to interrupt, then they can.
Thank you, Madam President. Issue number 5 is the board's fund condition, and just providing an update on that. Issue number 6 has to do with physical and mental health conditions that impair the physician's ability to practice. Issue number 7 has to do with the postgraduate training license. And there's no specific prompt. We do have a proposal later on the agenda that deals with that. Issue number 8 is the Mexico pilot program, asking us to provide statutory updates. We'll be talking about that, those 2 bills later on today. Number 9, mandatory reporting. Again, this is our own proposal. The evidentiary standard is number 10. We touched on that a moment ago by Dr. Thorpe's comments. Number 11, subsequent arrest reports. That's a proposal of the board. Same with 12, the letter of advice. 13, similarly, is our own proposal. 14 is also our proposal about probation modification and delaying the opportunity for pushing back the timeframes for folks to apply for penalty relief under their probation. 15 is a kind of a hodgepodge, so to speak, of various enforcement proposals that we have included in our sunset report. Number 16 has to do with the enforcement monitor and touches on the proposals that are in there. 17 has to do with various technical changes. I think they're getting at licensing changes. And again, we have a number of those. And then 18 is whether or not the board should continue on. And I think we all agree that the board should be renewed for a 4-year period.
Thank you, Mr. Bone. Are there any comments or questions from board members? Or I will also entertain a motion to delegate the drafting of the responses to board staff and then to the board president and vice president for review.
I had a question, Madam Chair.
Please.
Erin, for this document with the different issues, I was just curious in terms of serving it up to the legislature. You know, I see how it's broken into sections, and I'm wondering if an alternative, which I'm sure you thought about, is prioritizing, you know, maybe some of them, like the top 5, and then breaking it down. You know, I'm just worried of whoever's reading this kind of losing steam as they go from 1 to 18, and maybe some of the more pressing ones are in the middle or at the bottom.
So I think we could certainly include like a cover letter that would be my suggested approach, to perhaps include like a cover letter that kind of reaffirms the board's priorities. Those are included already in the board's report. There's a cover letter signed by the president that talks about our financial condition, and then the complainant liaison unit. Those are the board's top 2 priorities. That's affirmed later on in the details of the board's legislative proposals in the Sunset Report. If we wish to kind of, you know, restate some of those things, I would recommend that we do that through some sort of a cover letter. This issue volume, these 18 issues are not necessarily a priority order. That's just the order in which the legislature decided to document the different issues. It's not necessarily as well exhaustive of all of our priorities, but it is a way to kind of like tee up the discussion for the hearing that occurred last week. So I don't know, I hope that's helpful, Ms. Libiano.
No, thank you. That's helpful. And I'm supportive of a cover letter too. I think any chance to reiterate kind of the most important top issues is always helpful. You know, I've probably said this to folks here before, but, you know, I read something where it takes 11 times to see something for it to sink in. So I'm all about that kind of repetition. So,
yeah, and I would just, my pleasure. And I would just say that I think that our presenters last week did a very good job of hitting on those really key priorities for us.
Yes, thank you. No further comments from me. And I'm happy to make a motion to delegate to our president, vice president, and staff to see this through.
Thanks, Libiano.
Helzer, second.
So we have a second from Dr. Helzer. Any further discussion before we call for public comment?
Madam Chair, this is Dr. Thorpe. I would just like to add my thanks to you and Dr. Hawkins and staff for your excellent representation of the board during Sunset Review, and I just want to say you have my confidence as well. Thank you.
Thank you. Any additional comments? All right, Sean, if we could open it up for public comment.
Yes, very good. The Q&A window in the hand raising feature are still active for anyone wishing to make a public comment. Not seeing any call-in users at the moment, but if any do join, they can press *3 in order to toggle raising their hand. First up here, we have Marion Hollingsworth. Marion, you should be receiving that request.
Okay, I got it.
We can hear you, Marion. Please
Okay,
go ahead.
great, thank you. Good morning. My name is Marion Hollingsworth, patient safety advocate. Regarding these issues, number 1, composition of the board. I believe it would be more effective if this board had a public member majority to ensure public safety is a priority. Regarding the claim on issue number 4 that you say complainants are kept up to date on the status of their complaints, this really doesn't happen. Complaints are kept in the dark and are not even complainants are kept in the dark. and are not even told when a decision is made. They have to watch for your website to find out for themselves. I support any action that will improve communication with complainants. Regarding number 10, burden of proof, I support the move to change the burden of proof to preponderance to be in line with the rest of the country. It seems to be the CMA position that doctors are above being held accountable, so holding them accountable would make patient safety more of a priority again. Regarding issue number 12, letter of advice, I urge you to drop this issue. The board already has a lenient approach to 90% of cases and fails to even impose the minimum discipline stated in your own disciplinary guidelines. I know firsthand that letters to doctors have no effect. I was told one of the doctors in my complaint was given what was called an educational letter, urging him to reach the highest level of care. There was no formal discipline. A short time after receiving this board letter, this doctor overdosed a patient with 480 Vicodin in a 7-week period and ended up on your death certificate project. You waited until a patient died before actually imposing a discipline because you thought a letter would work. Finally, number 18, should the medical board continue to regulate doctors? Your document says the public is best protected by a strong regulatory board. The problem is the public is not being protected. You're giving sexually offending doctors their licenses back. You allow doctors to remain in practice after they've had multiple deaths. And you are even having your own board member subpoenaed to protect doctors at hearings. I can name case after case where you gave a discipline below your own guidelines. On top of that, you are insolvent and even say cases are being dropped because you can't afford to prosecute them. I don't know what agency would be best to regulate doctors in California, but the medical board as it stands now is not able to handle the job. Thank you for your time.
Thank you for your public comment. Up next here we have Tracy Dominguez. Tracy, let me go ahead and send you that request. Morning, Tracy. Looks like your line's open.
And I am from Bakersfield, and I am a volunteer with Consumer Watchdog. One of these issues we have discussed with you for the past few years is the one needed for consumer input into the enforcement process. I can speak on this issue because I am one of the few who had a complaint go through your complete enforcement process. I had to do everything I could, including working directly with Michelle from Consumer Watchdog to push my complaint through the consumer unfriendly process. We have advocated for 3 steps to be inserted legally into your enforcement process, with our priority of requiring an interview of the family member before your complaint is dismissed. Your idea for a complaint liaison unit came from our recommendations, but you have not incorporated our solutions with your liaison unit. I reviewed the responsibility of the unit and they will not make a difference. We need you to incorporate the required interview of the complaint before the quality of care, death, or serious bodily injury complaint is dismissed. We really need the 3-step for serious input, but you really need to meet us halfway and incorporate the interview. Otherwise, you're asking the legislature for funding for a unit that will not make any difference. Also, the information on the report is inaccurate. I did not receive letters throughout the process. I received the initial letter we received on our complaint, but I never received another letter that included once a settlement was reached. I only learned the settlement through Michelle. Issue number 9, mandatory reporting. We agreed that the organization that the employees or contact with a physician must be reported to any discipline action taken against a physician due to a medical disciplinary case. We need these disciplinary actions noted on the physician's profile. I am specifically requesting that the 805 report received by the board be noted on the physician's profile, especially in the loss of hospital privileges. This is an issue that's already been discussed and agreed to move forward. Oh, hold on, I'm sorry. Already discussed, and for this issue has already been discussed and agreed to forward process in the sunset issue. I am personally experienced with a lack of information that can mean to a family who has a family member in the hospital and assessed to a doctor who has lost privileges to 2 different hospitals. I can
30
mean,
seconds remain.
okay, I'm sorry. It can mean the difference between life and death. In this, my daughter and grandson's case, the lack of information contribute greatly to their loss of their lives. Issue number 10, I agree with the burden of proof must be lowered to preponderance of evidence across the board. It doesn't make sense to have 2 different burden of proofs to the staff to utilize. I realize the legislation wants 2 different standards to focus on a higher standard of revocations, but in all accusations, with the revocation stayed with a standard, would
Please conclude.
the board ever use the lower burden of proof? To make it simple, a burden of proof at preponderance of evidence. Thank you.
Thank you very much for your public comment. Next up here, we're going to go back. Monty Goddard is trying it again. Okay, so Monty, you should be receiving a prompt on your computer or mobile device there to unmute. Even though you've called in from a phone line, you still are connected by a computer or mobile device. Need you to unmute from there. Okay, Monty, I sent you some chats back too, so hopefully you can take a look at those and we'll see if we can get you on here again in a second. Next up, we're going to go to Lucas Evanson. Lucas, you should be receiving that prompt on your end. Well, Lucas, looks like your line's open. Please go ahead. Lucas, are you there? Okay, you're unmuted on WebEx, but you might have another mute on your computer or something else going on with your microphone there. So go ahead and put you back on mute and we will come back to you. Christina Hildebrand's up next. Christina, you should be receiving that prompt.
Hi there, Christina Hildebrand with Voice for Choice Advocacy. While we appreciate the recommendation to create the complainant liaison unit so that the medical abuse victims have assistance in navigating the medical board's complaint process, we still don't feel that this goes far enough in giving these victims a voice during the process. This is something that a Voice for Choice Advocacy, as well as many, many other consumer advocates, have asked for years and years now. And the medical board pushes stuff forward that gets you partway there, but doesn't get you anything close to what consumer advocates are asking for. You make out in the Sunset Review document, and it's copied over into the legislature's Sunset Review, that basically falsehoods that the victim has the right to know what's going on, the right to give input, gets to know about the process all the way along. It sounds great what's written in there. It doesn't happen though, and you and I both know it, and you're basically lying to the legislature on what is actually happening. The victim isn't allowed to share their information before their complaint. There's no follow-up statements, no rebuttals to the accused doctor's statements allowed. The victim nor any corroborating witnesses are allowed to appear or give evidence at the medical board panel hearings or the Office of Administrative Hearings. The victim has no right to access the accused doctor's statements or receive copies of their own medical records provided by the doctor during the investigation. On many occasions, you have a disciplinary settlement agreement because you don't want to move forward with the full thing because you don't have enough money. And there's nothing, so it saves you money, but the victim has no input into that. They can't disagree. They can't appeal the decision. They can't appeal the decision at any point. In fact, they can't appeal it if it's let go and considered not valid to move forward. They can't appeal the decision to have a disciplinary settlement. They can't appeal the decision at the end if they don't agree with what the accusation or the disciplinary action was. The accused physician, on the other hand, hires a lawyer, experts to represent them, and have the full gamut of everything else. Whereas the medical board lawyers are supposed to represent the victim, but how can they do that if they never interview them, never speak to them, and the victim has no say in the case?
30 seconds for me.
I would ask you for once to listen to the public comment and don't just shove things down our throat that you think fulfill what we're asking for. They don't. The patient liaison unit or the complainant liaison unit does not do anything of what we're asking for. So I once again ask that you today make the ethical and right commitment to include in the sunset review language and the bill language that gives the victim a voice and an opportunity to provide additional information, testimony, and their own expert witnesses under the California standard of implied good faith and fair dealing, and treat them as the client and the
Please conclude.
party in deliberations rather than sidelining them. A Voice for Choice Advocacy is happy to share bill language that we put together. Thank you.
Thank you for your public comment. Next up here, we're going back to Lucas Evison. Lucas, I see you've called in now. Let's see if we got this.
Hello,
Lucas,
can you hear me?
We can. Please go ahead.
Okay, great. Hello, Lucas Evanson on behalf of the California Medical Association. CMA appreciates the opportunity to provide public testimony and appreciates the committee raising the question about whether the board's application questions discourage physicians from seeking mental health care, and hopes the board takes issue number 6 seriously. Physicians have a suicide rate higher than the general population. For male physicians, it is 1.41 times higher. For female physicians, it is 2.27 times higher. Additionally, 28% of residents experience a major depressive episode. Medscape does an annual survey on physicians on burnout and depression. In the 2022 survey, 43% noted not wanting to risk disclosure to the medical boards as a reason for why they haven't sought care. CMA has heard from numerous residents and program directors that the questions they are both asked regarding resident mental health stigmatize and even discourage seeking mental health. Most recently, I was told about a physician who told her program director she sought mental health treatment. The program director disclosed this to the board, and the board issued her a probationary license, which disrupted her residency. At the end of it all, this physician told her program director that would be the last time she ever seeks mental health treatment. We ask the board to please support revision of the application questions to align with our recommendations made by the Federation of State Medical Boards and review other policies and practices which might discourage physicians from seeking treatment. Thank you.
Thank you for your public comment. Next up here, we have Monty Goddard. Monty, it looks like you're connected via computer audio now, so let's give this another shot. Monty, on your computer side, you should be seeing a little pop-up box asking if you'd like to unmute. Okay, Monty, I'm sorry you're having troubles today, but it looks like we're not getting a response here. So kind of move on to Michelle Montserrat Ramos. Michelle, you should be receiving that prompt on your end. Michelle, are you there?
Good morning. I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. Issue 1. We support the need to change the composition of the board. We believe that a public board member majority will provide a more equitable position on issues that support both consumers, promote consumer protection, as well as support physician licensing issues. Issue 4. We have presented to this board for several years now the need to give consumers legal input into the enforcement process. I personally presented this issue to the medical board many years prior. It has been said here that physicians have 4 avenues to provide input during the CCU process while the public has no input. It has been determined here that families are at a disadvantage at this critical stage that determines whether a complaint goes to investigation or whether it is dismissed, like the majority of Californians are. While we appreciate the work you're putting into creating a complainant liaison unit, the responsibilities you have outlined show that this unit is not addressing the issues that we have brought forward. The public needs a required complainant interview in this process. Otherwise, you're asking for funding for a unit that will not make a difference. The public will still not have input into the enforcement process, and this board will continue to be pressured by the public to give us a voice and to do better. Funding is an issue, and we know this, but if you're going to ask for funding for this unit, please enable this unit to help the public, and that will be a required interview for death and serious bodily injury complaints before they are dismissed. Issue 11. We agree that changes must be made to ensure that this board receives subsequent federal arrest and conviction reports as well as state arrest information. We also need to ensure that the board is utilizing the National Practitioner Data Bank to make sure that your staff has all necessary background information. Issue 12. We discussed this last sunset review. There is no need for a letter of advice. You already have the letter of reprimand to address these issues. The language from the previous sunset bill is not too restrictive. The letter of advice should not be used for any patient care complaint. Issue 14, we agree that BMP 2307 needs to be amended to lengthen the time a doctor who is disciplined can request reinstatements or early termination of probation. We agree that the guidelines for reinstatements should be increased from 3 years to 5 years before a doctor can reapply for reinstatement of their license. We also agree that the amount of time needed to lapse before a doctor can apply for early termination of probation needs to be
30
extended.
seconds remain.
You can save funding by making these changes, and just as importantly, you can provide protections for the public. We know what it takes for this board to revoke a license or settle with a physician to encourage them to surrender. They are so few, and the cases against them are so egregious, and many times the licensees are repeat offenders. We need to find ways for this board to save funding while providing consumer protection for patients, and this is definitely one recommendation that will do a fine job of doing both. Thank you.
Thank you for your public comment. Try Monty here one more time. I'm going to send you the calling information that should also be in your registration email that you received there too, Monty. But let's see if you can see the prompt at all. Okay, yeah, we're not able to get Monty unmuted here. So at this time, President Lawson, I don't see any additional requests in queue.
Thanks, John, and thanks to all of those who made public comments. We'll bring it back to the board. We do have a motion pending. Is there any further discussion before we call for the roll call vote? All right, seeing none, members, if you could please unmute your computers, and then Ms. Lopez, if you could please perform the roll call vote.
Dr. Ballat,
Yes.
Mr. Brooks,
Yes.
Dr. Hopkins,
Yes.
Dr. Hilzer,
Yes.
Dr. Mahmood,
Yes.
Mr. Rue,
Yes.
Dr. Sai,
Yes.
Dr. Thorpe,
Yes.
Madam President Lawson.
Yes. All right, that motion passes. Members, please remute your computers, and we will move on to agenda item 6, which is discussion and possible action on a legislative proposal related to the postgraduate training license. Mr. Bone again.
Thank you, Madam President and members. As discussed in prior board meetings, the board began receiving an exceptionally high volume of licensing applications starting last year, particularly from those with a PTL who are transitioning to a physician and surgeon license. In the board's sunset report, the board stated its desire to explore statutory changes to allow the PTL to be issued for longer than the current 15 or 27 months, with the goal of providing PTL holders a longer window of time to transition to their physician and surgeon license. This item before you is a legislative proposal in line with the sunset report and would lead to a PTL being issued for a period of 36 months, similar to how the law worked prior to 2022. This change is intended to provide PTL holders additional flexibility to make the transition to a physician and surgeon license. To be clear, this change would not require licensees to maintain their PTL for 36 months. Rather, it would allow them to stay with the PTL for that period of time if they wished, provided they remain enrolled in their training program. Further, eligible applicants could still move to a physician and surgeon license as soon as they successfully complete the required amount of training. This proposal does not change the requirements for obtaining either a PTL or a physician and surgeon license. It merely provides more flexibility in the process, including more time for applicants to remediate deficiencies or other issues that arise during the application review process, and hopefully limit any impacts to their ability to practice. The proposed statutory changes are included in the final page of this write-up. Staff recommend the board approve the proposal and direct staff to distribute it to the legislature and seek its inclusion in the board's sunset bill. That concludes my prepared remarks, Madam President. Staff are happy to answer any questions.
Thank you. Are there any questions from members?
Dr. Hawkins, just curious whether there's any downside to this, particularly like here from Ms. O'Connor.
Hello, good afternoon, or still in the morning. Good morning, board members. Yes, as far as a downside, definitely not a downside in the processing of applications. It's really a benefit because it allows the board and the applicant more time to get through their transition from a PTL to a physician surgeon's license. As Mr. Bone stated, they can work on any deficiencies they have. If there's additional questions board staff have or additional information we need before issuing a physician surgeon's license, it provides us and the applicant more time to work on that so that their PTL doesn't expire before we finish that application process, before they're issued a physician surgeon's license. So from a processing standpoint, there really isn't a downside that we can anticipate at this point.
Thank you.
I guess I would just add that we still need applicants to submit their documents in a timely manner. So this doesn't necessarily help with that aspect, but it does provide more time for folks to navigate through the process.
Thanks for that reminder.
Madam Chair, I move that we authorize staff to forward the recommendations in a legislative proposal to amend the current language.
Thank you, Dr. Thorpe. Is there a second?
Second, Hawkins.
I think the second was from Dr. Hawkins, maybe Dr. Balat. Any other questions or comments before we go to public comment? All right, seeing none. Sean, if you could open it up for public comment, please.
Yes. Thank you very much. Here we've got the Q&A window in the hand raising feature. For any call-in users, please go ahead and press *3 to toggle raising your hand. First up here, we have a call-in user from the 951 area code. You should be receiving a prompt on your end to press *6 in order to unmute now.
Good morning. My name is Monty Goddard. This call is going to be short. I was testing to see why for this entire meeting I could not get called on. It's working this time. I have a public comment for agenda item number 3 that I was not allowed to make. I was not able to make. How can I get that comment on the record?
You can make it now, sir, or you can also send it to us in writing.
Okay, I'd like to make it now. It's short.
Please.
Good morning. My name is Monty Goddard. Thank you for this opportunity to speak at this meeting. I speak as an advocate for my wife and all those suffering from severe chronic pain. I endorse the earlier comments made by Kristen Ogden. My comment is a slightly reworded repeat of the one I made at your full board meeting last month. What is happening with the boards Dr. Thorpe and Mr. Brooks led, very much appreciated and eagerly anticipated effort to improve the plight of severe chronic pain patients and that of the California's shrinking number of brave pain management physicians willing to provide them adequate care. What is the status of the board's updating of your opioid prescribing guidelines? Inquiring minds, actually anxious minds, want to know. Please provide a status report. Thank you.
Thank you, Monty. Next up here, we have Dina McRae. And Dina, you should be receiving that prompt on your end. There you go, Dina. Looks like you got the line open. Please go ahead.
Okay, great. I wasn't sure if you could hear me.
We can, yeah.
Okay, fantastic. Thank you. Good afternoon. I'm Dr. Dina McRae, Interim Associate Vice President for Academic Health Sciences for University of California Health. System-wide, the University of California trains almost 6,000 residents and fellows, which is approximately half of the total for the whole state of California. I'm here today to discuss the medical licensure process as described in SB 806. University of California Health System has 2 requests. One, to eliminate the requirement that the resident must be in the same program for 24 months in order to be eligible for renewal of a license. This requirement leads to training programs turning away strong applicants. We should be trying to find ways to increase our number of residents and increase our workforce, as you know, especially since California ranks at the top of the nation in terms of the retention of medical residents who stay on to practice in our state at 77%. There are highly qualified and desirable applicants interested in transferring to one of our reputable training programs, but they wouldn't have the 24 months in a single program required for licensure. For example, a family medicine residency program in the San Joaquin Valley may get approval to expand in order to address that community's medical needs. And they might need to recruit senior residents to fill their new positions. If an out-of-state PGY2 family medicine resident who could be performing at the top of their class in their current program and want to transfer mid-year to be closer to their family, and they have plans to practice in that community, but they wouldn't have those 24 months in the same program that's required by the medical board. So while the resident would qualify for the initial license, they wouldn't qualify for a renewal, and then he or she would need to move out of California to actually practice medicine. Our second request is, yes, we agree with the medical board. The PTL should be valid for a longer period of time, and we're grateful for this action. We want to make sure that they are still, though, eligible for a full physician surgeon license after 12 months of successful training. Just as you had discussed, this would provide a larger window of time for the medical board to review the thousands of applications, and thank you for doing so, and for the very busy intern to complete paperwork and address any issues with the application. The current system has the intern quickly turning around. They get the PTL.
30 seconds remaining.
And then they have to complete the physician surgeon license paperwork. And then also this helps with their moonlighting. So of note, though, I just want to make sure the medical board's aware when calculating the years of training credit, there should be consideration of appropriate leave, such as for medical or family reasons. So in summary, the University of California respectfully requests that you please consider eliminating the requirement that a resident has to be in the same program for 24 months in order to be eligible for renewal of a license. And we thank you for considering lengthening the time that the PTL is valid, but also have eligibility for full license after 12 months. Thank you.
Thank you for your public comment. Next up here, we have Lucas Evanson. Lucas, you should be receiving that prompt.
Hello, everyone. Thank you. Lucas Evanson on behalf of the California Medical Association. CMA appreciates the time medical staff have put towards addressing some of the issues that have arisen during the implementation of the PTL. CMA is supportive of the medical board staff proposal and would like to reinforce the points made by Dr. McCray. We support the elimination of the 24 consecutive months in that change to their proposal. We are sympathetic to our residents' frustrations and are optimistic about the positive changes these proposals will make moving forward. Thank you.
Thank you for your public comment. This time, President Lawson, I don't see any additional requests in queue.
Thank you, Sean. We will bring it back to the board. I have forgotten who made the motion and seconded it, but I do know that there's one pending.
I have Dr. Thorpe and Hawkins.
Terrific. Thanks,
Hawkins,
Aaron.
for a question.
Yes, please.
So I wonder if Carrie and perhaps Marina might remind us the rationale for that 24-month in the same program. What we felt was the benefit and the rationale for that. Input from Carrie and Marina, please.
This was a change that actually Dr. Bishop, I don't know how many of you remember Dr. Bishop, who was on the board, really championed so that residents would have to stay in the same program for at least 24 months so that any deficiencies would have the opportunity to be resolved, rather than what may happen where someone gets through 1 year or a partial year of their program and then they move on to another program and can do this consecutively until they meet the requirement for licensure. and maybe they get the credit, but deficiencies are not resolved. Whereas if someone has to stay within a program for 24 months, the program in resident may have more commitment to remediate appropriately. So that's where it came from. I don't know if Marina has
O'Connor,
any
do you
other
have any
comments.
comments? And actually, I apologize, but I wonder if Dr. Bullock might chime on anything in academic medicine and involvement program in these training programs. But Marina O'Connor, do you have any comments? Anything else to add? You don't have to, but I'm just asking.
No, I don't have anything else to add. That is my understanding as well of the decision behind going for the 24 consecutive months.
On this point also, I mean, we've had a process whereby we've reviewed, for example, licensing applications where the residency program has shut down for one reason or another, at least that's my recollection, and then they've had to transfer to a different program. Maybe you could just speak to how we've been handling those requests. I did hear from the commenter about, what if you'd like to make a change for family reasons, or there's this, interesting, new program that is available that wasn't previously available. How have we treated some of those issues in the past?
Also, medical reasons.
Precisely, right.
Correct. If we have applicants who maybe don't have exactly 24 consecutive months in the same program due to typically reasons outside of their control, such as medical reasons, they had to take a leave of absence, or care for a family member and had to transfer to a new program. We do review those on a case-by-case basis with the application review and special programs committee, and determine, because the statute does allow us to determine, I might not use the exact correct wording here, substantial compliance or similar compliance with 24 months. So if we can say, okay, based on the circumstances, based on all the other factors we look at when we look at their training and their eligibility for licensure, that they have completed equivalent to what we would expect them to obtain with 24 consecutive months in a program, then we can accept that as equivalent to that requirement. But again, it's on a case-by-case basis with the review of the committee as well.
Thank you.
Thank you. Before I hang up the mic, can I just, and I apologize, Dr. Bullock, I mean, you're in training programs, teaching programs. Do you have any comments about this?
Yes, as I'm reflecting on the 24 months and Dr. Bishop, as well as some of the boards requiring 24 consecutive months to become a member of a particular board, maybe at the American Board of Family Medicine, American Board of Internal Medicine. Some of those requirements are beyond the postgraduate training. It's after the graduate completes his or her residency. I think that the example provided, or the examples provided, are important, since we do know that physicians, it used to be, physicians would stay in the community in which they trained, and we know that we have a much more mobile group of individuals. My one caution, and I think you asked that, Dr. Hawkins, would be, and to Marina, what is the downside for public protection if someone is going to be dismissed from a program? Sometimes program directors may just simply not renew a one-year contract. So I don't know how we would be able to know that. And I think that was part of what Dr. Bishop was concerned about, that as a program director, I can dismiss you and you are kind of right now, you really can't get you have to apply to a new program. So I think Dr. Hawkins asked the right question. Are any of us here to assure the public and everybody at this board, is there a downside from all of the data you have and what you see? So those are my comments, Dr. Hawkins.
Thank you very much.
Additional comments or questions?
Madam Chair, this is Dr. Thorpe.
Dr. Thorpe?
Thank you. And I appreciate Dr. Bullock and Dr. Hawkins' questions. I will have to say, I have seen I've had a number of, I shouldn't say I've had a number. I've had 4 residents talk to me about problems relating to this specific issue. Somebody who does a internal medicine first year in one program, and their wife who's ahead of them gets the opportunity to work in another community. For instance, guys in a program in Loma Linda in the central or in the Inland Empire, and his wife gets a job in San Diego. It's a difficult thing for him to work in San Bernardino area, and for her to work in San Diego. He gets an opportunity to have a position in San Diego, but he won't fulfill the 24-month consecutive month issue. And so it's, he's a great candidate. He's got no problems, but just because of this, this issue, he would like to move to another community. And, it's very discouraging for those folks who are young doctors who want to try to develop a life in the midst of their training programs. Secondly, I would say I don't want to say this incorrectly, but the doctor who was the head of the associate head of the program at University of California, we specifically want the best candidates here in California. And so to decrease our pool of excellent candidates by requiring this 24 months, I understand the concern about terminating someone and then not knowing for sure how to, what their issues are. There is a balance. Part of the problem, part of the issue of protecting the public is getting excellent doctors. So it's not just disciplining the bad doctors, it's also making sure we get good doctors. And so I think we've got a challenge to try to, I don't think we should eliminate a required amount. I'm not sure it should be 24 months. I'm not sure what the amount is that would be appropriate. Does it need to be more than a year? And I don't know technically how that would work, but I have to say I would be in favor of loosening the 24-month requirement.
Thanks, Dr. Thorpe. Additional comments?
I have one. I think overall this issue we're debating, whether we change it to a year or 24 months, I think in looking at the macroscopic picture, it'll only apply to a small percentage of people. So we don't want to miss the forest and just looking at the trees. So just so everybody knows, this is not a significant issue that'll impact a large portion of the residents.
Thanks, Dr. Tsai.
Yeah, and I would ask then for the follow-up to that is, what is that percentage and do we know? That's do we know? And data is very important, and that's the transparency. So do we know?
I don't know that we know how many we miss, right? Who don't apply because, or don't switch programs for one reason or another. We certainly have data on those who have come to us and where, to Marina's point earlier, have asked, for, I don't want to say an exemption, that's not the right word, but have asked for consideration of their circumstances from the application review and special licensing. I think application, but did I get that right? I might have just gotten that wrong too, but I've asked for that consideration. I do serve on that committee, so I've seen those come through. And I've seen how we've dealt with them over the past couple of years. And I mean, perhaps, I don't know if there's a legislative option of making clear what that discretion might be on those case-by-case circumstances, because right now we are using that substantial compliance essentially with that 24-month requirement, and are making certain determinations under that provision. So perhaps there's an opportunity for us to provide more clarity that we will, again, entertain applications that have those types of extenuating circumstances, if you will, because we have had a host of them, like I mentioned. In one case, programs shut down. In one case, I recall reviewing one where a resident was in a particular program, I think radiology, and wanted to switch to another one, and that was going to be problematic. So I think it's worth us considering how we can make sure there's flexibility for people to make really good choices for themselves and for Californians.
So Ms. Lawson and I on that same committee. Marina, can you remind us, do we prioritize those? I remember we had special meetings to address those particular physicians who had an issue. Were they prioritized?
As far as prioritized processing them ahead of other applications, no. When we find out about it during the application process, we of course try to address it as quickly as we can, internally and with the committee. But oftentimes this is something that comes up after they're licensed, because it is a renewal requirement, and this is a new renewal requirement. So this just went into effect January 1, 2022 for licenses issued January 1, 2022 or later. So as far as numbers go, we're just starting to see these come in more often now. And unfortunately, I don't think we'll really know the exact extent of it until those folks are coming up for renewal. But in the meantime, as we become aware of them, as a program director or a licensee reaches out to us and says, hey, I'm considering, transitioning to a new program, is this going to become an issue? Then we address it. And so, I think that's something we'll have to think about internally, is if the volume increases, what does that process look like ongoing based on those numbers? Because as President Lawson points out, we may not know all of them, because they may not have reached out to us yet. They may not know about the new law even, or they may not know what the pathway forward is. And so we really need to, work on what does that look like? How do we communicate that to licensees as they're coming up for renewal? But they often have to make those decisions they often have to know whether they're going to meet the renewal requirement before they make that decision. That's the tough part, is, they're coming up on maybe renewal in a year or so, and they want to consider transferring to a new program, but they don't know if that's going to jeopardize their ability to renew. Is the board going to accept, their training as equivalent to 24 months? So they often have to seek out, our determination prior to them making a decision to transfer. And so it's difficult, the timing of it, to make sure that we're able to address it timely so that they are able to make that decision before the new program they're transferring to is maybe giving them a deadline. Hey, we need to know if you're going to transfer to us by a certain point of time, and we have to then, as a board, make a decision by then. So we're just in the first year of this new law, and seeing how it goes, seeing how many are coming up. What does that process look like internally? So unfortunately, we don't have a great idea of what the numbers are going to look like going forward. But there has been, a good handful just in the last year. I'd say probably, other than we did have a program closure where this did come up. It did impact a significant number of licensees. But aside from, a program closing, I'd say we've had probably less than 10 come up in the last year.
Thank you.
Madam Chair.
Yes.
I just one other comment, and that is, I know that there are requirements in place assuring, competencies and assessment of performance through the ACGME and the appropriate board requirements. And when the institutions review the applications of these transfer, the institutions are not going to want to bring somebody who's incompetent into their program. It seems like changing the 24-month, at least to 12 months, then it would give, we can, these programs are in a way, they're self-policing, because they have serious requirements to be able to be board certified, and to be able to assure that they actually have competencies that are intact. We certainly aren't the ones who are going to ensure that those things occur. It's the individual programs that actually ensure that the candidates are competent in each of their areas. So maybe we're being a little bit too, I don't know, prescriptive in this area. I certainly don't want to minimize the importance of recruiting competent doctors, but at the same time, I want to make sure we don't turn away competent doctors who want to come here because of this arbitrary 24-month limiting, this kind of arbitrary limitation because of the 24-month renewal period.
Dr. Thorpe, I appreciate those comments, and I mean, Aaron, correct me if I'm wrong. We don't have a proposal currently in our proposal that relates to this specific issue, correct?
Yes, that's not specifically contemplated in this.
Now, to the extent, I'm hearing, or at least sensing, that there's some interest in figuring out how to resolve this. I just to offer my own point of view on this, this idea that we would potentially include in legislation some discretion in those cases where there is a time discrepancy. That's where I'd like us perhaps, or that's where, again, my preference would be to focus the discussion there. And, setting aside whether it's 12 months or 24 months, the timing requirement is actually what can be problematic. And I'll offer the example of even in a 12-month program, if a parent, for example, needs to leave on parental leave, 11 3/4 months into their program, and for some reason hasn't achieved that exact 12-month benchmark, that could still be problematic, but they may very well still qualify, and their program director may issue a letter that says, no, they really have met that 12-month requirement, notwithstanding that they're essentially a week or 2 weeks short. And so I think that we should have the flexibility at the board to make those judgment calls where there's again, some type of time discrepancy for one good reason or another. So I'd love to focus our energy on trying to figure that out rather than focus our energy on trying to figure out is 12 months, 18 months, or 24 months the right number of months.
Yeah, I would agree with that, Madam Chair.
Madam Chair, last comment. I was just going to say that I completely concur with that. The one question I would ask is to make sure that, is there a letter in good standing that that person left that program in good standing? And if that is part of the process, that's very important, because that program director is stating this person left in good standing, and which is part of any type of any resident that completes 12 months, 24 months, or whatnot. That is an important, I think, consideration. But I concur that the 12 months, 24 months, and all of these time, it's more of what are we doing and being transparent about how we make the decision.
Right. So we have a motion and a second. So the motion pending actually does not address this issue at all. We can vote on that motion, then we can take up, I guess, provide direction on this issue. I don't know, Carrie or Aaron, you want to help me out about what we would need to do on this second issue that we've been discussing now?
That piece, that specific piece isn't agendized.
Okay.
And so, it could be something that we discuss at the May meeting. And, certainly the individuals who are advocating this before the board today can advocate for that with the legislature as well for consideration.
Okay.
Yeah, I agree with what Ms. Webb said, and then as well as, I'm taking notes. We've got the recording. We've got a lot of good input from the board, right, to help kind of guide that next discussion. And this aspect occurred to me as I was reflecting and listening to the comments, and maybe Ms. Webb or Ms. O'Connor can correct me, but under this proposal, you'll be able to have a PTL for as long as 36 months, right? Well, as I understand it, the 24-month requirement comes into play, and that's in BPC section 2097. That comes into play, I believe, when they are renewing, right? Well, you're not going to have your initial renewal until you have a physician's and surgeon's license to renew. But if you are in, if you continue and you gather your required postgraduate training under the PTL, not through the physician and surgeon license, then that might provide a subset of the folks who are experiencing this challenge right now some additional flexibility. I hope I said that clearly, and Ms. Webb and Ms. O'Connor will correct me, but there may be something that we're kind of helping out in this regard anyway through this proposal.
Thanks. And so let's move to a roll call vote on the pending motion. And I think what you're hearing is clear direction that we're interested in further conversation on this issue. And so perhaps that can come back at our May meeting, and perhaps there will even be some legislation or something in print for folks to react to at that point as well. All right, so Ms. Lopez, if we could move to a roll call vote on the proposals that are part of our agenda today.
Dr. Salat,
Yes.
Mr. Brooks,
Yes.
Dr. Hawkins,
Yes.
Dr. Hauser,
Yes.
Ms. Lubiano,
Yes.
Dr. Mahmood,
Yes.
and Dr. Sai,
Yes.
Dr. Thorpe.
Yes.
Madam President Lawson.
Yes, that motion carries unanimously.
You skipped me, David
Oh.
Rue.
Mr. Rue.
Yes.
Sorry about that. All right, it still carries unanimously with Mr. Rue's vote included. All right, we will move on to the next item, which is item 7, discussion and possible action on legislation. Mr. Bone, it's your show again.
Thank you, members. This is now about discussion on legislation that's already been introduced. If you look at the green and blue colored tracker chart, you will see that there are 7 bills listed there. For the 2 items shaded in blue, I'm recommending that we do not discuss and take action on those at this meeting. There are analyses in there so that the members are aware of the issues that are being presented, the policy matters rather that are being presented in those bills, but further significant amendments are expected. And therefore, I recommend we wait until there is more time for those bills to develop. There is one other unusual for us feature for this meeting's legislative discussion is that we are proposing to discuss 2 particular bills at the same time. This is under agenda item 7D, which covers both AB 1395 and 1396. Those 2 bills pertain to the Mexico pilot program, so it seemed that the conversation will be more productive to discuss those 2 bills at the same time rather than separately. So with your permission, Madam President, I will proceed to AB 470. Great. This bill updates continuing medical education or CME requirements to encourage physicians to pursue CME courses that improve the quality of physician-patient communication in a manner that is culturally and linguistically competent. The bill provides the criteria, updates the criteria for CME courses to emphasize the importance of improving the quality of physician-patient communication. It also adds certain requirements that accrediting bodies must follow if they update CME standards related to cultural and linguistic competency for the practice of medicine in California. This bill is not expected to change the board's workload associated with auditing a physician's compliance with CME requirements. AB 470 is expected to help support the cultural and linguistic competence of physicians in the state who serve a diverse population. Staff recommend a support position on this bill, and I'm happy to answer any questions.
Any questions or comments? And remind me, Carrie, we do a motion on each bill, correct? So we're going to do bill by bill and public comment by
Yes.
bill.
So, Madam President, couldn't we just go through all the bills and do a public comment at the end?
I think we need to do it bill by bill because we have to take a support or opposed position on each bill.
That's right.
Okay.
I have a question, Madam Chair.
Please.
So, Mr. Bone, do we have the associations that accredit CME courses are already operating at a very thin margin financially. It's a very difficult space. Many people that offered CME previously don't offer it anymore because of the multiple restrictions and the multiple regulations relating to CME. This is just one more thing. And if they have to pay an advisory group to give them expertise in cultural and linguistic competency. It just seems, is it really, I'm not trying to say that cultural competency is not important. I'm not trying to say linguistic competence is not important, but does it really impact the actual continuing education that people are getting in a way that is significantly impacting the effectiveness of that education, to pay somebody to say, you know, that we're doing this in a culturally and linguistically competent way? I am not convinced that it does, and I'm concerned that it would, in fact, negatively impact these associations that are offering CME already at marginal financial capabilities, and would mean that others would subsequently withdraw from this space.
Thank you for that, Dr. Thorpe. Couple thoughts in response. The first is that the language does not mandate that the standards be updated. It states that the associations that credit may update their standards, and if they are going to, then they shall do so in accordance with the requirements that are laid out.
Well, it says AB 470 would make two changes. Number one, update the general criteria, must meet to emphasize the importance of improving the quality, etc. And then on the second one, it says further in the second sentence, on the second bullet point, it says further, the standards are required to be updated with an advisory group that has expertise in cultural and linguistic competency issues and is informative, etc. You know, but it's required, it says, to be updated.
Yes. So in the preceding sentence under that bullet, provides that the associations that accredit CME courses may update their standards. And then in the second sentence, that the standards, I do see your point, Doctor, I regret any miscommunication, but the second sentence about the standards being updated is contingent upon their election to do so. So that, and I'm looking at the language of the bill right now.
In other words, if they elect to do so, then they must do it in this particular way, but they need not elect to do it.
Yes, yes. And I believe that we have the sponsor, which is the California Medical Association, that we have them, I believe, on the line. And I would expect that they've been listening, and we'll be happy to try to speak to those concerns as well, Doctor.
I'm just haven't had a chance to review the bill, but I want to review the bill because your language in the summary is not clear, Aaron, and it's very concerning to me that is a requirement.
I regret the lack of clarity, Doctor. I'm looking as well at the language of the bill itself.
So in the bill itself, under 2190.1, item subset B, item 3, it says under A, the standards shall be updated in conjunction with an advisory group. Shall be updated in conjunction with an advisory group that has expertise in cultural and linguistic competency issues, and etc. So it does say shall be, which implies it's a requirement.
In the preceding line, if you look at B3, so you were just reading from B3A. In the preceding line, B3, and this is existing law. This is law that is not being amended in the bill. It says associations under current law, associations that accredit continuing medical education courses shall develop standards before July 1, 2006 for compliance with the requirements of paragraph 1. The associations may update these standards as needed. That's an existing law. And then it adds in accordance with the following requirements.
I see.
And the it's already in current law that they must do so in conjunction with an advisory group that has expertise in cultural and linguistic competency. Okay. So the language is developing that out in more detail.
Thank you.
And I regret the lack of clarity in my analysis, but thank you.
Let's move this along. Any additional comments from board members? Dr. Helzer?
Mr. Bone, would this bill place any new requirements on licensees for required courses?
No, Doctor. CME is largely permissive, right, in the types of coursework that physicians are able to choose. And no, I do not see any specific coursework that's being required under this bill.
Thank you.
We have a motion to approve the staff recommendation, or other thoughts?
I move to approve the staff recommendation.
Thank you. And I'm seeing a hand from Dr. Mahmood. Is that a second?
Yes.
Thank you. All right, let's open it up for public comments.
If the hand raising feature in the Q&A window is open for anyone wishing to make a public comment. Just a note that the panelists during the meeting do not have time or really the ability most of the time to review what you're typing into the Q&A. So the Q&A window should only be used for requesting public comments. So just note that any comments you're typing in there aren't being reviewed in real time by the panelists. So first up here, we have George Soares. George should be receiving a prompt on your end there.
By 1 minute. Just here to answer any questions and well, just and provide kind of the background.
Sorry, George, can you redo your introduction there? There was some background noise kind of.
Can you hear me?
We can hear you now, but there was something, we didn't hear your introduction. Go ahead and start.
Sorry about this. George Soares, legislative advocate with the California Medical Association, was just here to provide comment on AB 470 by Assemblymember Valencia. I was listening to the conversation from a few minutes ago and just kind of wanted to clarify what our intention with the bill is. It is to simply reaffirm the importance of physicians knowing that this is an option to take CME or language classes to become more linguistically and culturally competent in the healthcare setting, and to use that as a CME credit. So we're just we're getting in there and ensuring that it is updated, ensuring that physicians know that it is an option. So as some of the folks on this call said, it is not any sort of new requirement on physicians or the accreditors. So just wanted to just kind of set that straight, and happy to provide any questions or feedback or answer any questions.
Okay, thank you for your public. Sorry, there's background noise there. Thank you for your public comment. Next up here we have Roger Liu. Roger, you should be receiving a prompt on your end.
Dr. Roger Liu. I'm the Director of Medical Education in the Ultimate Institute for Health Equity. Ultimate Health Services is the largest federally qualified health center in the United States. We provide high quality, comprehensive care to more than 500,000 Californians and have been a trusted healthcare provider for Latino, multi-ethnic, and underserved communities in Southern California for over 50 years. I'm requesting a support position for AB 470 that will allow healthcare professionals to better understand, communicate with, and effectively interact with their patients from diverse backgrounds. Californians represent a wide diversity of ethnic, racial, and religious backgrounds, and at least 43% speak another language other than English. This creates a disparity between the number of physicians who speak of foreign languages and patients where English is their second language, resulting in worse satisfaction for patients and providers, worse access, quality, safety, and health outcomes, use of high-cost medical services, and the exacerbation of other social barriers. AB 470 would expand access to quality foreign language courses that would be offered to physicians in addition to their pre-existing continuing medical education requirements to improve their linguistic competency. Patients need to be able to effectively communicate with their physicians so they can trust that their concerns regarding their health are being addressed appropriately. AB 470 will reduce the widening language gap between patients and their physicians. Thank you for this opportunity to speak.
Thank you for your public comment. This time, President oops, sorry about that, Roger. I'm trying to put your hand down. This time, President Lawson, I'm not seeing any additional requests.
Thank you. We'll bring it back to the board. And please let me know if you've got any additional comments. Otherwise, we'll move to the roll call vote on the support position.
Dr. Hawkins, I agree with support. I just would encourage someone to clearly articulate the rationale for this so that you understand that this is a recommendation for individuals to improve their ability to communicate with citizens of California who are of diverse backgrounds, just to clearly articulate it. Because when you think about CME, you think about taking a course. So that's my only comment.
Thank you. All right, Ms. Lopez, if you could please call the roll.
Dr. Ballant.
Yes.
Mr. Brooks,
Yes.
Dr. Hawkins,
Yes.
Dr. Hauser,
Yes.
Ms. Lubiano,
Yes.
Dr. Mahmood,
Yes.
Mr. Rue,
Yes.
Dr. Sai,
Yes.
Dr. Thorpe. Madam President Lawson.
Yes. All right, that motion carries. We're going to move on to the next bill. Aaron?
Thank you. That is AB 765, which prevents anyone from using a medical specialty title or to refer to themselves as an osteopathic medical doctor without being licensed as a physician. The bill includes numerous examples of specialty titles associated with physicians, but is intended to encompass any title that indicates or implies that the person using it is licensed to practice medicine. This bill is expected to add clarity and certainty for consumers regarding their healthcare providers and hopefully avoid confusion about the qualifications of their chosen provider. Staff recommend a support position, and I'm happy to answer any questions.
Thank you. Are there any questions?
I move support.
Thank you.
Dr. Helser, second.
Thank you. All right, any further comments before we go to public comment? All right, Sean, let's open it for public comment.
Sure, yes, the hand raising feature in the Q&A window is still open. Anyone wish to make a public comment, just go ahead and raise your hand or type something in there. First up here we have, George Soares again. George?
Hey, all. Thank you. Just George Soares, the California Medical Association, voicing strong support for this legislation and helping to ensure patient safety in the healthcare setting. Thank you.
All right, thank you for your public comment. Not seeing any additional requests at this time.
All right, let's bring it back to the board. Any comments or further discussion? All right, Ms. Lopez, if you could call the roll on our support position for AB 765.
Dr. Balad,
Yes.
Mr. Brooks,
Yes.
Dr. Hawkins,
Yes.
Dr. Hauser,
Yes.
Ms. Lubiano,
Yes.
Dr. Mahmood,
Yes.
Mr. Rue,
Yes.
Dr. Sai,
Yes.
Dr. Thorpe.
Yes.
Madam President Lawson.
Yes. That motion carries. All right, we will move on to, I believe, AB 1395 and AB 1396. Mr. Bonta.
That's correct, Madam President. Thank you. AB 1395 would require the board to issue a license under the Mexico Pilot Program, or MPP, to an applicant without an individual taxpayer identification number or social security number, provided that the applicant meets all other requirements for licensure under this program. The license would not allow them to practice medicine, however, until they provide their social security number to the board and the board confirms that they have met the requirements under this bill. Staff do not have concerns with this proposal and recommend the board adopt a support position on 1395. The second bill, which is 1396, includes the same proposal in 1395 and an additional one that would allow an MPP license holder to request an extension of the expiration date of their license. Under current law, the MPP is issued for a 3-year period and may not be renewed. The extension proposal is narrowly crafted at the request of the sponsor and is intended to help licensees who are facing a delay in their practice due to a health condition or due to the time required to obtain a visa or appropriate credentials from health plans. Board staff have had multiple conversations with the sponsors of the bill, and the proposed amendments in the analysis reflect the board's attempt to identify and resolve the various necessary details so that the board may successfully implement an extension to these licensees. The members will hear from the sponsors during public comment. The details of the staff's recommended amendments are stated on pages 3 and 4 of the analysis, and again reflect the conversations to date thus far with the sponsors. Staff recommend the board adopt a support if amended position on the expiration proposal as proposed by board staff in the analysis. However, some of the details of the policy, particularly with regard to submission deadlines and the length of the expiration, requires more time to work out. Therefore, staff suggests that the board not authorize a support position until the board is able to review the language at a future meeting after all the matters have been hopefully addressed. This concludes my remarks, and we're available to answer any questions on these two bills and the suggested positions. And I believe, Madam President, any motion approved should include the position on both bills because we're dealing with this as a single agenda item. Thank you.
Thank you. Any questions or comments?
Madam Chair, I have a question.
Please.
So, Mr. Bone, if we were to make a motion, it's a little confusing, but it does sound like AB 1395, you're recommending that we authorize
support.
And support, I mean, authorize a support position. But 1396, it's support if amended. So if we take both, I mean, it would be easier to separate these two issues out, it seems to me, to take a vote on 1395 and then, you know, address 1396 if it needs to be amended. I'm not quite sure how to do it in one motion. I guess that's my question.
I don't know if Ms. Webb maybe can offer some advice on the separation or the inclusion of the two items into one motion.
I think you could make a motion to approve staff's recommendation under AB 1395 and to approve staff's recommendation to take a support if amended position under 1396. So it'd be one motion that covers both of these related topics.
So moved.
Thank you.
Second.
Great. Any other comment or discussion?
Who was the seconder? Was that Mr. Brooks?
We have Mr. Brooks. Any additional discussion before we ask for public comments? I know there's a number of interested people on the line. All right, Sean, let's open up for public comments, please.
Okay, the hand raising feature in the Q&A window are open for anyone wishing to make a public comment. Any call-in users can press *3 to toggle raising your hand there as well. First up here, we have Arcadio Viveros. Arcadio, you should be receiving that request.
Good afternoon. My name is Arcadio Viveros, member of the Board of Directors of San Benito Health Foundation, one of the participant organizations in the pilot program for the AB 1045 Mexican physicians program. We are, the reason for my presentation was to ask you for the support, and thank you for doing so in your motion. I just want to let you know that in the rural areas where we're located, it is very difficult to recruit physicians, and it is very difficult to recruit physicians that are culturally and linguistically competent in providing adequate medical services to the populations that we serve. So this pilot program with Mexico is a blessing to us and to the other organizations that are participating in it. As you know, 30 physicians from Mexico and 30 dentists could, once it becomes a full program, it would render tremendous assistance to the clinics in serving those needed populations. And those populations are located and living in medically and professionally underserved communities. The mission of San Benito Health Foundation is to promote quality, affordable, and comprehensive health services to San Benito County and to the other areas nearby in the Central Coast of California. Most of San Benito Health Foundation patients are Spanish-speaking with low-income resources. This program it provides the ability for us to serve those patients with quality services throughout the program in this county. We have 5 physicians right now that are in 4 have been already licensed by the board. Thank you, board, for doing this. And 1 is in the process of getting approval. We know that other organizations are participating and they can speak on their own, but we are very much in support of what you do and how you've been able to help us in
30
this.
seconds remain.
Thank you for registering the support for AB 1395 and 1396. And we urge you to continue helping us. Thank you very much.
Thank you for your public comment. Next here we have Roger. Roger, let me get you called on there. Roger, should be receiving
Thank
that
you.
prompt.
Thank you. First of all, completely agree with our brother and sister Community Health Center. Good afternoon. My name is Dr. Roger Luna. I'm the Director of Medical Education and Ultimate Health Services. We're the largest federally qualified health center in the nation. And for over 50 years, we have proudly cared for the most vulnerable patients in Southern California, regardless of their ability to pay. I'm requesting a support position on AB 1395, which is a technical fix to the existing 3-year licensed physicians and dentists from Mexico pilot program. At this very moment, community health centers across the state, including Ultimate, are already hosting 30 physicians from Mexico under this pilot. A support position on this bill would address barriers to licensing currently experienced by healthcare professionals that is exacerbating the physician shortage experienced in our communities. Now, for over 25 years, I have trained thousands of physicians. However, the few that choose to practice in an underserved community has come to the point where I call them unicorns. Although I strongly believe in growing our own, there is even a greater urgency in caring for our patients that are suffering right now in our clinics. The ability to bring in a highly experienced, highly trained, Spanish-speaking primary care physician that wants to care for our patients is nothing short of a miracle. I have personally worked with these licensed physicians from Mexico, and not only do I vouch for their medical competency, I would trust my own children and family to their care. Again, I request for a support position on AB 1395, and I thank the board members for your time and consideration.
Thank you for your public comment. Next up here we have Rosa Vivian Fernandez. Rosa, you should be receiving that prompt on your end.
Of San Benito Health Foundation, a community health center located in Hollister, California, serving San Benito County and surrounding areas. We are one of the participating organizations, and like Mr. Viveros stated, we thank the board for approving the 4 clinicians that we currently have on board. And to do so, starting in 2021, when we were in the midst of the pandemic, in a really precarious situation where we had one of the physicians start in August and the other one in November of 2021. Last year alone, they provided over 13,000 visits. There were fewer visits than expected because one of the clinicians was on maternity leave and the 3rd clinician started later in the year. We have the 4th clinician that started in January, and we have a clinician that's waiting the licensure and visa process for May, and a 6th clinician with that same period. The reason for the license request prior to Social Security is that we need to apply for the visa, and it's very difficult to get that visa approved. And it creates a delay in the process of having these individuals start work. And the program is for 3 years. So basically any delay cuts into their 3-year period. And I know we're not talking about 1396, but I would urge also support of 1396, because for technical reasons, we actually cut into this period of time because it may take 3 to 4 months to start to practice after they receive the visa, because in order for them to practice, they have to have a social security number. In order to credential, you have to have a social security number, and you have to have an ID. In order for you to get an ID, you have to have a social security number, and you have to have 2 pieces of mail come to you. And so this whole bureaucracy creates a 3 to 4 month period in which they are not starting to practice. And that's unfortunate because we have a 3-year limit. And like I said before, the PDL also cuts into, or other extended leaves cut into that 3-year period. We urge you to support 1395 and 1396 in order for us to add our additional 2 clinicians and the other clinicians that are coming to our sister clinics. Thank you.
Thank you for your public comment.
I just want to clarify for the commenters that we are taking both of these bills together, 1395 and 1396. Thank you.
Thank you, Carrie. Next up here, we have Fabiola Moreno. Should be receiving that prompt there on your end. Fabiola, it looks like your line's open. Are you there? Hey, Fabiola, it looks like you're having some microphone issues. Go ahead and put you back on mute there to double check your audio settings, and let's see if we can get you in. We'll come back around. Next up here, we have Laura Stapleman. Laura, you should be receiving that prompt on your end.
You there?
Yes, Laura, we're here. Please go
Yeah,
ahead.
okay, thank you. I am Dr. Laura Stampleman, and I am the chair of the Quality Assurance Committee of the Board of Directors of the San Benito Health Foundation. And again, I want to speak in support of your support of these 2 bills. From a quality point of view, I have been very pleased with the function of our physicians through the Mexico pilot program. They are enthusiastic, they are well-trained, they are continuously interested in more education, and I hope that we can continue and expand this program. And I thank you for support for these 2 technical fixes, which will allow them to continue for their full 3-year term. Thank you.
Thank you for your public comment. Just a sec here. Graciela Soto. Let's go to Graciela Soto. Graciela, you should be receiving that prompt on your end. Looks like the line.
Thank you. I want to request support for AB 1395 and 1396. My name is Graciela Soto Perez. I am the Chief Executive Officer for Altura Centers for Health. We are located in Tulare County. That's Tulare, south of Fresno. We've been currently battling a lot of floods right now in our areas and some evacuations in some of our county areas. So we are a participant of the AB 1045 program, very fortunate. They've been wonderful to work with. It takes us years to recruit and especially retain providers into Tulare County. We lose providers to the coast, to Southern California, Northern California. So this is a big issue for us in terms of having providers to treat our population here in the Central Valley. We the Mexican doctors have already treated over 9,000 visits. Those are 9,000 visits that we have been able to taken care of, and that's only with 3 doctors practicing last year. So we now have 4 that are practicing, but 1 has not been credentialed. He arrives in September, and it just takes a very long time to get the Social Security, the license, like Rosa Vivian said. In addition to that, the credentialing from our health plans, over 120 days, and that 120 days is not just for Mexican MDs, as you all know. If you're a doctor when you hire, and Medicaid will not let you have patients be treated without being credentialed. And so those are the barriers we encounter. However, once they are able to work, it's been excellent. We also have trouble with one of the providers. The immigration kept on refusing his status due to, they wouldn't give him his green card because he had not passed his USMLE, which would have been not applicable, but that was out of our hands, and it took over a year until he was finally able to get granted approval. Some of the process of having our Mexican doctors, they come with specialties. Some of them are pulmonologists, cardiologists, ER specialists, and we've been using that to the fullest, especially in the Central Valley where we have a lot of respiratory issues. And so having a pulmonologist at hand with that expertise has also been a plus, and they've been a wonderful asset. So I just request again if we could have the support for AB 1395, AB 1396 to continue to take care of all of our populations in the Central Valley. It's not just a certain demographic, but all of our American population here in the Valley. Thank you.
Thank you very much. Going back here to Fabiola. Fabiola, let me try this one more time. You should be receiving a prompt on your end to unmute. Okay, so you're unmuted, Fabiola. Are you there?
Hi, can you hear me?
We can. Yeah, please go ahead. Thank you.
Oh, you can? Awesome. Thank you so much. My apologies for that. My name is Fabiola Moreno, and I am here on behalf of Office of Assembly Member Eduardo Garcia. Thank you to the board for your collaboration on AB 1395. Specifically, Erin, thank you so much for being in constant communication with us for a couple of months. We welcome all the suggestions that you have had and just look forward to working with you. Thank you.
Thank you for your vote on. This time, President Lawson, I don't see any additional requests in queue.
Great, thanks, John, and thanks to all the commenters. Bringing it back to the board, are there any other further discussion points? All right, seeing none, I think we have a motion on the table for a support position on 1395 and a support if amended on 1396.
Yes.
All right, Ms. Lopez, please call the roll.
Dr. Balat,
Yes.
Mr. Brooks,
I didn't hear Mr. Brooks.
It looks like he's off mute.
Yes.
But, yeah.
Sí. Sí, claro.
Dr. Hawkins,
Yes.
Dr. Hauser,
Yes.
Ms. Lubiano,
Yes.
Dr. Mahmood,
Yes.
Mr. Rue,
Yes.
Dr. Sai,
Yes.
Dr. Thorpe,
Yes.
Madam President Lawson.
Yes. All right, that motion carries. And then we're moving on to the last bill, I think, SB 373.
Yes. Switch my screens. It's the final bill for discussion today, which prohibits the board from publicly disclosing the address of record of any licensee who practices psychiatry, except their city, state, and zip code would be published. The bill applies similar prohibitions to the licensees and registrants of the Board of Behavioral Sciences and to the licensees and registrants, licensees and registered psychological associates under the Board of Psychology. The bill is intended to help promote safety among mental health providers. The analysis provides links to some articles that note increased prevalence of verbal and physical aggression experienced by those professionals. Fortunately, current law already provides a mechanism in line with the goals of the bill. As noted in the analysis, any physician may provide the board with a P.O. box, which would avoid the publishing of their physical address on our website associated with that individual. Publishing a full address of record, whether it includes a full physical address or a P.O. box, provides consumers the opportunity to verify the identity of a physician from whom they are seeking services. It also provides a means to facilitate communication with their physician, seek a copy of medical records, or serve legal documents. Further, other state law requires health plans and insurers to publish the practice address of their contracted healthcare providers. Therefore, it's not clear to the staff how this bill will help achieve the intended goal of promoting safety. In light of these considerations, staff recommend an opposed position on SB 373, and I'm happy to answer any questions, Madam President.
Thank you. Any questions? Is there a motion?
So, Aaron, I just want to be clear. You believe existing law already covers the safety of psychiatrists, so this bill is not needed. Is that what I'm hearing?
Yeah, I would put it this way, Mr. Brooks. Existing law already provides a pathway for a physician to not disclose a physical address associated with their practice. That's current law for medical board. They can provide a PO box, and then that will be the address of record that we would provide on their physician profile.
Okay, thanks.
I move to oppose the bill.
Hi, this is Michelle. I'm so sorry. I don't think you could see my hand before we talked.
Sorry about that.
That's okay. I just want to be clear. So the reason that you suggest that we oppose the bill is because we are asking a group of doctors and that are mental health providers to purchase a monthly post office box. Is that right? That's an alternative. Am I correct? I mean, it's the only way you can do that. It's a monthly post office box. Okay.
That is the existing alternative, doctor. But then in addition, the analysis notes the benefits for consumers by having an address that they can use to make contact with the physician. And then further, and I recognize the difficulty and the sensitivity of this topic, so I certainly don't mean to give any of that short shrift. The practice addresses are required under separate law for health plans to publish those widely, and not just for those who subscribe to XYZ health plan, but that also that they're made available to the public. So I think, right, so that somebody can look and say, oh, I want Dr. Bolat, she's great. Okay, does she take my insurance, right? Is she contract with me? Oh, I live in Sacramento, darn it, I can't see her in UCLA. Yeah. So when you're given the totality of those, factors, doctor, that's where we arrived at the opposed recommendation.
No, and I got that. So I think that's really, thank you for that clarification. And I think doctors just need to be reminded they don't have to put their home address, their practice address.
Yes. And I had I think a good amount of back and forth with the author's office and the sponsors. Outlined asked a lot of questions and outlined a lot of concerns, with them, provided them this analysis last week, as is my practice. And so I think they're very I think, and I hope that they're very understanding where at least the staff are coming from in this. I do see Ms. Webb's
hands up. Yep.
Yeah.
Thank you.
Yeah, and just to emphasize that we don't license by specialty. And so how do we track? You can have a primary care physician or an internist offering counseling. And so do they qualify to have their practice address or address of record, rather, blocked from being on the website? It just doesn't seem practical.
Thank you very much. That's really good discussion. Thank you.
Yeah, I move to oppose just because, I mean, typing your name in a Google search will reveal way more information than your medical board website.
Thank you. Do we have a second?
Yes. Second.
Terrific. A second from Dr. Helzer. And we'll go to public comment now.
Yes, the Q&A window and the hand-raising feature activated. Anyone wishing to make a public comment on this agenda item, please do either of those, or if you're on a phone-only line, you can press *3 to toggle raising your hand. All right, I'm bringing it up to your attention here, President Lawson. Arnaldo Torres was just waiting to make a public comment on the last bill. Didn't raise his hand or get in a Q&A answer in time, I guess. So I don't
Okay, I'm happy to hear from him for a minute, but I think we voted to support the bills.
Yeah,
There's no
other requests in queue here, but
Does
let me go
Mr.
ahead.
Torres want to speak for a brief period of time?
Ronaldo, you there? Your line open?
If I may?
Yes, please go ahead.
I just wanted to, I think the other speakers have made it, express their concerns and their support for the two legislative pieces. I did want to thank Mr. Bone. I did want to thank all of your staff, Chairman Lawson and Chairwoman Lawson and board members. This program has been a fantastic success up to now in the populations that we serve. You've heard the concerns about linguistic and cultural competency and the importance that they provide. It has been an extremely positive working relationship with Ms. Webb, with Ms. O'Connor, with Ms. Frankel, and with Mr. Bone. You've had a difficult day hearing a lot of negatives. We're very happy to say that we finally have been able to hit a good stride in working this bill through. And we are 100% in agreement that we will resolve those differences on 1396. We're generally in agreement. We'll just finalize the language, put it in legislative form, and then you will have it back before you, probably within the context of the sunset cleanup legislation that both the business and professions committees will be submitting to you. But 1395 is an urgency clause, and that's the only reason why we needed the support position at this hearing today. But again, I want to thank you very much. We've really do appreciate working with board staff on these two items. It has been a very, very positive change and a very positive direction for the future. Thank you.
Thank you. All right, well, let's refocus on whether there's any public comment on SB 373.
At this time, I don't see any requests in queue.
All right, we'll bring it back to the board then. We do have a motion pending. Is there any further comment? All right, Ms. Lopez, if you could please call the roll.
Are you on any?
Dr. Balad,
Yes.
Mr. Brooks,
Yes.
Dr. Hawkins,
Yes.
Dr. Hauser,
Yes.
Ms. Lubiano,
Yes.
Dr. Mahmoud,
Yes.
Mr. Rue,
Yes.
Dr. Sai,
Yes.
Dr. Thorpe,
Yes. Sorry.
Madam President Lawson.
Yes. All right, that motion carries, and I think that was our last bill for consideration today.
That's it for me. Thank you.
All right, thank you, Mr. Bone. We're going to move on to the next agenda item, which is our last agenda item, future agenda items. And I will call on Mr. Brooks first because he had one from before, and then we'll go to other members. Mr. Brooks.
Yeah, thank you, President Lawson. And I'd like to agendize for maybe the next meeting and have this,
Mr. Brooks freeze for everyone or just for me?
I'm increasingly
Mr.
getting
Brooks?
more and more.
Yeah, Mr. Brooks.
Mr. Brooks?
Yes.
Sorry, you froze for a minute there, so we missed your proposal. So
Oh, I'm sorry. Can you
Sorry,
can you hear me now?
Yes,
Can you hear me
we
now?
Yep.
Okay, thanks. You know, I'm getting I'd like our attorney to have a conversation or propose some new rules when it comes to public comment. I'm getting increasingly concerned about the lack of decorum and personal attacks during public comment period. We've seen, throughout, the nation, some of these comments have led to violence, led to people coming over someone's homes. I don't think it's healthy. I learned a lot from public comment, and I think the public comment period has made us a better board, especially when it comes to policy and direction. But I am concerned about the vitriol and the lack of decorum during our session. So I would like to have our attorney provide us with new guidelines to hopefully stem that to avoid something negative happening.
Thank you. All right, other potential future agenda items?
Madam Chair, this is
Yes.
I just wanted to will we, is the, is the proposed, the new guidelines for the opioid prescribing, is that on the May agenda?
I believe that we're currently anticipating that that will be on our May agenda. I don't see any reason why it would be taken off, but that's the current thinking. Yes.
Okay. Well, I just wanted to reassure people that we are, Mr. Brooks and I and the staff are working diligently to try to complete those. We've had a few minor editorial comments to try to take in the breadth of public comment and policy expert comments that we've achieved through this last year, and it's been a very good process. I think there's been a lot of input, and we've tried to be we've actually tried to do some things that are different, and so I'm hoping that but it is very complex, and we've got lots of moving parts. Our making a change in policy is not going to affect the DEA. It's not necessarily going to affect, workman's comp. It's not necessarily going to affect health plans or the major state and federal payers. So or the pharmacies. So we've got a fair amount of work to do. Even if we do change, even if you all decide to adopt this policy, as we anticipate we'll be able to have a good discussion in May. But just to let people know, we are continuing to meet. We are working, and we think we've finalized our last editorial comments, and so we should be ready to present in May.
Terrific. Thank you. Thank you. Additional future agenda items from board members?
President Lawson, I wanted to follow up on what you mentioned during our discussion on the PTL. So I think that would be important, but also if there could be some consideration, I know we'll have a packed agenda in May, but sometime in the future for consideration for possible guidelines to allow program directors somehow an ability to have conversation with the medical board, that it may be something that right now, as it stands, a resident under training to which the program director has oversight to validate competency cannot speak with the board without written permission from the resident or fellow. And I think that maybe there could be a nice sea change to be able to be part of the contractual agreement in some way. So something to think about in the future.
Thank you. Additional future agenda items and a couple of just observations. Obviously, our May 18th through 19th meeting, I believe, is being held in Sacramento. We are currently planning, as of right now, to hold our August board meeting in the Bakersfield area. Additional future agenda items, or should we open it up for public comment? All right, let's go to public comment, Sean.
Yes, so the hand raising functionality and Q&A window are open. Anyone wishing to make a future agenda item suggestion, you can do either of those, or if you're on a call-in only line, you can press *3 to toggle raising your hand. First up here, we have Christina Hildebrand. Christina, should be receiving that request.
Hello, Christina Hildebrand from A Voice for Choice Advocacy. Can you hear me?
We can.
I have two agenda items. One of them is one that I ask for every single time, which is actually three. I have three. One of them is that you give time in each board meeting to a consumer advocacy group on a specific topic for them to give you information and educate the board on a topic. I ask that you do that. The second one is for and I know there has been one in the past, but it didn't quite cover what I was looking for it to cover, a discussion on or presentation on standard of care and how that is actually defined by the medical board and the potential of having an actual definition and what doctors can use as a definition of standard of care when they're looking at using methodologies or treatments that are not within the realm, that are new treatments or breaking edge treatments, cutting edge treatments that are not necessarily the standard in the world or in California. There may be other places in the world. And then the third one is that you create a presentation on, because there is a divergence in what you as the medical board say a patient or a victim, the input that they can have in their complaint process versus what the actual experience is for victims. And maybe it's that the victims just don't know that they can give additional information, or that they have more of a place for a voice than they do currently. And so if you could put forward and go through the complainant process and each step of the process and outline exactly where a victim can give additional information that is beyond just when they submit the form, so that we are all on the same page of where the patient can have an additional voice. Thank you.
Thank you for your public comment. Next up here, we have Marion Hollingsworth. Marion, you should be receiving that prompt.
Okay, here I am.
We can hear you, Marion. Please go ahead.
Thank you very much. It's Marion Hollingsworth, Patient Safety Advocate. Regarding future items, as I said earlier in this meeting, could we have one on conflicts of interest, and also the application of AB 1636? And I'm also concerned about the call for censoring public comment. I've been watching this board for a long time, and I have seen doctors get riled up, stand up, shout. I have seen public members being vehement and pleading for help from you, but not threatening. And if you're referring to the confrontation earlier with a board member, this was from a doctor and not a member of the public. So I would hope that this board would not want to censor public comment, because this is the only way we have of actually interacting with you and to get you to understand our viewpoint. So I would hope that you would not choose to do that. Thank you.
Thank you for your public comment. Next up here, we have a call-in user from the 951 area code. Should be receiving that prompt on your end to press *6 to unmute.
Good morning again. This is Monty Goddard. It worked that time. I just got to say, after listening to Dr. Thorpe's comment about a future agenda item, thank you very much, Dr. Thorpe. You're a positive light on the horizon of pain patients in this state. I do want to call the board's attention to something they might want to look at in a future meeting. There's a bill that was just introduced in the Assembly, 1751. If you read that bill, it is a direct attack on the California Pain Patient Bill of Rights and the Intractable Pain Act. I just want to make sure that bill is on you guys' radar screen. Thank you.
Thank you for your public comment. I'll check here. Next up here, we have Eric Andrus. Eric, you should be getting that prompt. Hey, Eric, it looks like your line's open. Are you there?
Can you hear me?
We can. Yeah, please go ahead.
Oh, okay. So, you guys, I just tuned in right now. I've been at the hospital with my partner who's dying in need of a lung transplant. I have a medical board complaint filed, but I haven't heard anything back on it, so I'm assuming that's gone by the wayside. But I just wanted to, I didn't hear David's comment about stifling public comment, but it seems like periodically we have to go through this with board members who try to stifle public comment, and we have to prove them wrong time and time again. It is illegal to stifle public comment. You cannot stifle public comment, David. And if you'll go back and familiarize yourself with past board meetings, like you should have before you became a board member, you would know that. And that's all I have to say. Thank you.
Thank you for your public comment. Double check one more time here, President Lawson. Yeah, I don't see any additional requests in queue.
Okay, thanks, John. We will bring it back to the board. Any last final future agenda items that board members wish to propose? All right, seeing none, the next item on our agenda is adjournment. So thank you to everyone for participating in our meeting today. Our next quarterly board meeting is May 18th through 19th. Dr. Hawkins is going to be leading the May meeting as I have a prior commitment. So I'll see you all again in Kern County sometime in August. And there being no further business, the meeting is adjourned at 12:50 p.m. Thanks, everyone.
Thank you, Madam President.
Thank you.
Thank you.
Thank you.